So Donald Trump just got absolutely blindsided by a judge who essentially told him to sit down and shut up. And trust me, this is not the kind of news his legal team wanted to hear. Just minutes ago, a judge flat out refused an emergency motion to pause the enforcement of asset seizures in his civil fraud case. We're talking about Trump Tower, 40 Wall Street, his golf courses, his entire real estate empire sitting on the edge of a financial cliff. And the judge? The judge basically said, no, you're not special, pay up. She'll pay. Let me fill you in on why this is an absolute catastrophe for Trump. His lawyers rushed into court with what they called an emergency application to halt New York Attorney General Letitia James from starting the process of seizing his properties to satisfy that massive $454 million judgment. They argued that enforcing the judgment while appeals are pending would cause irreparable harm. The judge read their motion, looked at the law, and said, denied. No hearing, no drama, just a cold, hard rejection. And here's the thing. This isn't some liberal activist judge looking to score political points. This is the appellate division applying basic New York civil procedure. When you lose a fraud case this big, you don't get to keep playing with your assets like nothing happened. You either post a bond for the full amount or you start watching the state inventory your properties. Trump's team couldn't secure a bond. No insurance company would touch him for $500 million. And now the consequences are rolling in like a freight train. Even Alan Dershowitz, a legal commentator who's defended Trump more times than I can count, is sounding alarms about what this means. He's not saying Trump's being treated unfairly. He's saying the system is working exactly as designed, and that's what should terrify the former president. Because when Dershowitz starts talking about the mechanics of asset seizure instead of constitutional overreach, you know the walls are closing in. This isn't just a story. This is a catastrophe unfolding in real time. This isn't just another legal motion that gets filed and forgotten in some dusty courthouse basement. This is the moment where Donald Trump's entire financial mythology gets stress-tested by reality. For decades, Trump has built his brand on the illusion of untouchable wealth, golden towers with his name in massive letters, private jets, golf courses stretching across continents, the image of a billionaire who plays by different rules. And now a judge in New York is about to pull back the curtain and show us whether any of that was ever real. Let's be real for a second. The civil fraud verdict that came down against Trump wasn't some minor fine. Judge Arthur Engoron found that Trump, along with his sons and his company, systematically inflated the value of his assets to defraud banks and insurers for decades. We're talking about claiming Mar-a-Lago was worth $739 million when it was realistically worth a fraction of that, saying his Trump Tower penthouse was 30,000 square feet when it was actually 11,000. This wasn't rounding errors. This was industrial scale lying to financial institutions. And Engoron hit him with a $454 million judgment, including interest that keeps climbing every single day. Now here's where the rubber meets the road. In New York, when you lose a civil case and want to appeal, you have to post what's called an appeal bond. It's basically insurance for the winner that guarantees they'll get paid if your appeal fails. The bond for Trump's case, the full $454 million. And despite all his boasting about being a multi-billionaire, Trump hasn't been able to get a single insurance company to underwrite that bond. His lawyers went to 30 different surety companies, 30, and they all said no. Why? Because insurance companies actually do their homework. They look at your real assets, your real liquidity, and they determine whether you're good for the money. And apparently when you strip away the branding and the bluster, Trump doesn't have nearly enough liquid assets to cover a bond this size. His wealth is tied up in real estate that's heavily mortgaged, and the cash he does have is scattered across legal fees, campaign expenses, and other judgments piling up. So Trump's lawyers filed this emergency motion arguing that seizing assets now would be unconstitutional and irreparable. They claimed that Letitia James was moving too fast, that the appeals process deserves more respect, that this was all politically motivated persecution, and the judge responded with essentially, "That's nice, motion denied." What makes this moment so critical is the timing. We're not talking about some far-off theoretical threat. Letitia James has already publicly stated that if Trump doesn't pay, she's prepared to start seizing assets. She's not bluffing. Her office has been doing the legal homework, identifying which properties are most vulnerable, which ones have the least debt attached, and how to execute on the judgment quickly. And the clock is ticking because every day that passes, the interest on that judgment grows by over $100,000. This is the first time in Trump's entire career where he can't lawyer his way into delay, can't settle his way out, and can't use bankruptcy protections to shield his core assets. The system is cornering him, and the judge just slammed the emergency exit door shut. Trust me, inside Trump's legal war room right now, there's absolute panic. Here's where the rubber meets the road. Let's talk about what actually happens when a judgment this size becomes enforceable and the defendant has no bond. Under New York law, Letitia James can begin a process called judgment enforcement. That's a polite legal term for what is essentially state-sanctioned asset seizure. And the terrifying part for Trump is that she has a menu of options. First, she can go after bank accounts. Any account held by the Trump Organization, by Donald Trump personally, or by the entities named in the judgment can be frozen and drained to satisfy the debt. We're talking about operating accounts, payroll accounts, reserve funds, everything. If Trump has $10 million sitting in a Chase account under a corporate entity, the Attorney General can serve a restraining notice, freeze it, and redirect it to the state. Second, she can place liens on real estate. A lien is a legal claim that attaches to a property and has to be satisfied before the property can be sold or refinanced. Letitia James has already identified properties like 40 Wall Street, a 72-story skyscraper in Lower Manhattan, and Trump's golf course in Westchester as prime targets. Once a lien is placed, Trump can't mortgage those properties for more cash, can't sell them without paying off the judgment first, and certainly can't use them as leverage in other deals. They become frozen assets. But here's the truly nuclear option. She can force a sale. If Trump doesn't voluntarily liquidate assets to pay the judgment, the Attorney General can ask the court to appoint a receiver who will sell Trump's properties at public auction. Imagine the optics. Trump Tower, the crown jewel of his brand, listed for sale by court order to satisfy a fraud judgment. The building that has his name in 5-foot-tall gold letters, getting auctioned off piece by piece because he couldn't secure a bond. That's not a legal footnote. That's a public execution of his entire brand. And Trump's legal team knows this. That's why they filed the emergency motion. The paperwork they submitted argued that enforcing the judgment before the appeals process is complete would violate Trump's due process rights. They cited case law suggesting that in extraordinary circumstances, a court can pause enforcement to prevent irreparable harm. They even trotted out the argument that seizing assets would interfere with Trump's ability to run for president, which is a Hail Mary if I've ever seen one. The judge wasn't buying it. In the denial order, the court made clear that Trump had every opportunity to post a bond, and his failure to do so was a consequence of his own financial situation, not some procedural injustice. The order specifically noted that Trump's legal team didn't present any new evidence or compelling legal argument that would justify an emergency stay. Essentially, the judge said, "You're asking me to bend the rules because you're famous and running for office. That's not how this works." Alan Dershowitz weighed in on this, and his analysis is chilling for Trump. Dershowitz, who has been a frequent Trump defender on constitutional grounds, pointed out that the appellate court's refusal to intervene suggests they believe the underlying judgment is solid. Appellate judges don't usually let enforcement proceed if they think there's a strong chance the verdict gets overturned. The fact that they're letting Letitia James move forward is a signal that they think Engoron's ruling will survive appeal. Dershowitz stopped short of saying Trump is doomed, but he made it clear that this is not the procedural win Trump's team was hoping for. Now let's talk about what happens in the next 72 hours. Letitia James has already sent demand letters to financial institutions where Trump holds accounts. Those letters are called information subpoenas, and they require banks to disclose what assets Trump has and where. Banks legally have to comply, and they will. Once she has a full picture of his financial landscape, she can start executing on the judgment with surgical precision. Trump's team has one remaining card to play. They can try to appeal this denial to a higher court. But here's the problem. The next level up is the New York Court of Appeals, the state's highest court, and they have discretion over whether to even hear the case. They could simply say, the lower court got it right, application denied. And if that happens, there's no federal hook to escape to because this is a state civil matter. Trump can't run to the Supreme Court and claim his constitutional rights are being violated unless he can manufacture a federal question, and so far his lawyers haven't found one. So trust me when I say this. We are watching the beginning of a financial unraveling. The judge just told Trump that the rules apply to him, and Letitia James is standing by with a legal toolkit designed to dismantle his empire piece by piece. Let me fill you in on what's happening behind closed doors, because the public statements from Trump's team are pure spin, but the private reality is absolute chaos. According to sources familiar with the situation, Trump held an emergency conference call with his legal team within an hour of the judge's denial, and the word that keeps coming up from people who were on that call: panic. Here's what you need to understand. Trump's legal strategy for months has been built on delay the trial, delay the verdict, delay enforcement. The theory was that if he could stretch this out past the election, he might win the presidency, and then the entire calculus changes. A sitting president facing state-level asset seizure is a constitutional crisis that could theoretically gum up the enforcement process for years, but the judge just collapsed that timeline. Instead of having until after the election to figure this out, Trump now has days, maybe weeks if he's lucky. Legal experts who specialize in judgment enforcement are calling this a nightmare scenario for any defendant, let alone one with Trump's profile. Barbara McQuaid, a former U.S. attorney and current University of Michigan law professor, said in a recent interview that once judgment enforcement begins, it's extraordinarily difficult to stop. She compared it to a freight train. You can see it coming, you can hear the whistle, but once it's in motion, there's no emergency brake. And right now, Letitia James is the conductor. Then you have Alan Dershowitz, who's been trying to walk a tightrope on this case. Dershowitz has argued in the past that the New York fraud case was politically motivated and that the penalties were excessive. But even he admits that the procedural posture here is brutal for Trump. In a statement released just hours ago, Dershowitz said, "The appellate court's decision not to intervene is significant. It suggests they believe the trial court acted within its discretion, and that's a very bad sign for Trump's appeal on the merits." Translation: if the appeals court thinks the judgment is solid enough to let enforcement proceed, Trump's chances of getting the verdict overturned just dropped significantly. Inside Trump's campaign headquarters, sources describe the mood as tense and fatalistic. Campaign advisors who've been confident about Trump's ability to weather legal storms are suddenly confronting the possibility that their candidate might not have the financial resources to sustain both a presidential campaign and a legal defense on this scale. One source, speaking on condition of anonymity, said, "We knew the legal bills were piling up, but we assumed Donald had enough liquidity to cover everything. The bond situation was a wake-up call. If he can't get 30 insurance companies to cover him, what does that say about his actual financial position?" And that question is now rippling out into the donor class. Major Republican donors who've been writing checks to Trump's campaign are reportedly asking pointed questions about whether their contributions are going toward winning the election or paying legal judgments. One donor who spoke to Politico on background said, "I didn't sign up to fund a legal defense that might end with his properties getting auctioned off. That's not a political campaign. That's a liquidation." The panic isn't limited to the campaign. Within the Trump organization itself, executives are reportedly scrambling to understand what happens if key properties get seized. 40 Wall Street, for example, generates millions of dollars in rental income every year. If that building gets liened or seized, does the revenue stream stop? Do tenants keep paying rent to a court-appointed receiver instead of the Trump Organization? These are questions no one inside the company ever thought they'd have to answer, and now they're staring down the barrel of those scenarios becoming reality. Even some of Trump's most loyal legal defenders are hedging their bets. Jonathan Turley, a law professor who's frequently appeared on Fox News to defend Trump, published a blog post this morning acknowledging that the appellate court's decision is procedurally defensible, even if he disagrees with the underlying fraud verdict. That kind of qualified support is damning in Trump's world. When your own defenders start saying the process is being followed, it means they're preparing the audience for the fact that you're going to lose. And then there's the clock. Every single day that Trump doesn't pay, the judgment grows by approximately $114,000 in interest. That's not a typo, over $100,000 per day. So even if Trump somehow manages to scrape together the funds to post a bond in a few weeks, he'll owe millions more than he does today. Letitia James has structured this perfectly. The longer Trump delays, the deeper the hole gets and the more leverage she has. Trust me, inside Mar-a-Lago right now, there are lawyers running spreadsheets, accountants trying to find hidden liquidity, and political advisors trying to figure out how to spin asset seizures as proof of persecution. But the reality is simple. The system just told Donald Trump that he's not above the law and he has no procedural escape hatch left. Let's be real for a second. This isn't just a legal catastrophe. This is a political nuclear bomb, and it's about to detonate in the middle of Trump's 2024 campaign. Because here's what his team is terrified of. The optics. Imagine the attack ads. Imagine the news chyrons. Trump's assets seized to pay fraud judgment. Trump Tower auction to satisfy $454 million penalty. Those aren't hypothetical headlines. Those are very real possibilities in the next 30 to 60 days. And the political damage isn't just about embarrassment. It's about the core narrative Trump has sold to voters for a decade. He's the successful businessman, the billionaire who can't be bought, the guy who's so rich he doesn't need donors or special interests. That's been his brand since he came down the golden escalator in 2015. And now independent voters are going to watch news coverage of the New York Attorney General cataloging his assets like a repo man inventorying a car. That shatters the mythology. Polling data is already showing cracks. A recent survey from Quinnipiac found that 62% of independent voters believe Trump probably or definitely committed fraud in his business dealings. That was before this enforcement crisis. Now add the visual of asset seizures, and you're not talking about abstract legal arguments anymore. You're talking about concrete proof that Trump lied to banks, couldn't pay his debts, and got held accountable. That's a narrative that breaks through to low-information voters who don't follow the daily legal minutiae. And here's the nightmare scenario that's keeping Republican strategists up at night: swing states. Pennsylvania, Michigan, Wisconsin, Arizona, Nevada. These are states where Trump won in 2016, lost in 2020, and needs to win in 2024 to have any path to 270 electoral votes. And in every single one of those states, the margin of victory in the last two cycles has been less than 2 percentage points. You don't need a massive swing in public opinion to flip a swing state. You just need a few thousand suburban independents to decide that Trump is too chaotic, too corrupt, or too broke to deserve their vote. The Biden campaign is salivating over this. Their entire strategy has been to prosecute the case that Trump is unfit for office, and now they have Exhibit A. Biden's team has already started circulating memos to surrogates with talking points about how Trump defrauded banks, lied to insurers, and is now facing the consequences. They're not even framing it as a political attack. They're just pointing at the court record and saying, look at what the judge found. That's devastating because it's fact-based and hard to spin. But the political nightmare doesn't stop at general election voters. Trump also has a Republican primary to think about. Yes, he's the prohibitive front-row-neck, but Ron DeSantis and Nikki Haley are still in the race, and they're both circling like sharks. DeSantis has already started making veiled references to electability and baggage, And you can bet that if Trump's properties start getting seized, DeSantis will hammer that message in Iowa and New Hampshire. Do you really want to nominate someone who might be liquidating his assets during the general election campaign? And here's the truly insidious part for Trump. He can't dismiss this as political persecution the way he does with criminal charges. The fraud case was a civil trial with a preponderance of evidence standard. There was no jury to blame. Judge Engoron issued a detailed 92-page ruling that methodically laid out the evidence of fraud. Trump's team tried to appeal it, and the appellate court basically said, the trial court got it right. This isn't Jack Smith bringing charges. This isn't Fani Willis in Georgia. This is a civil court saying, you lied, we proved it, now pay up. That's a much harder story to spin as a witch hunt. Republican donors are also getting spooked. Trump's campaign has raised massive amounts of money, but a significant percentage of it is going toward legal fees. According to recent FEC filings, Trump's Save America PAC has spent over $50 million on legal expenses in the past year. And that was before this enforcement crisis. Now, with the very real possibility that Trump will need to liquidate assets or secure emergency financing, donors are asking whether their money is funding a campaign or a bankruptcy. There's also the coalition problem. Trump's base will stick with him no matter what. We know that. His hardcore supporters see every legal action as proof of the deep state conspiracy. But Trump can't win with just his base. He needs suburban women. He needs moderate Republicans. He needs working-class voters who are economically anxious but not politically radical. And those voters? They see asset seizures and think, this guy is a mess. Do I really want 4 more years of chaos? Trust me, inside the Trump campaign, the political team is running scenarios, and none of them are good. If asset seizures happen before the Iowa caucuses, it dominates the news cycle and potentially gives DeSantis or Haley an opening. If it happens during the general election, it becomes a defining issue that the Biden campaign hammers every single day. There's no good timing for this. It's a political nightmare with no escape hatch. So let's zoom out for a second, because this case is about more than Donald Trump's bank accounts or his real estate empire. This is about whether the system works, whether someone with enough fame, enough bluster, and enough political power can simply ignore a court judgment because it's inconvenient. And right now, the answer we're getting from the New York courts is a resounding no. For decades, we've watched wealthy defendants use every trick in the book to delay, deflect, and ultimately escape accountability. They settle cases with non-disclosure agreements. They declare bankruptcy and shield assets. They hire expensive lawyers who file motion after motion until the other side runs out of money or energy. And the system, frankly, has let them get away with it because the machinery of justice moves slowly and money buys time. But here's what makes the Trump case different. Letitia James isn't a private plaintiff who can be worn down or bought off. She's the Attorney General of the state of New York, and she has the full resources of the state behind her. She doesn't need to settle. She doesn't need Trump to cooperate. She just needs the courts to follow the law, and so far they are. Judge Engoron issued a judgment. The appellate court declined to stop enforcement, and now the machinery is in motion. Alan Dershowitz made a fascinating point in his analysis. He said that this case is a test of whether America still has a functioning civil justice system that applies to everyone. If Trump can flout a $454 million judgment simply because he's famous and running for president, then the rule of law is dead. It means that wealth and power really do put you above the system, and every person who's ever lost a civil case and had to pay up was a sucker. But if the system forces Trump to liquidate assets, pay the judgment, and face the consequences of his fraud, then maybe, just maybe, the system still has teeth. And that's what makes this moment so critical. We're not just watching Donald Trump's financial empire potentially crumble. We're watching whether American institutions can hold someone this powerful accountable. Because if Trump gets away with this, if he delays long enough to win the presidency and then uses executive power to gum up the enforcement process, it's over. The precedent will be set. Future defendants will know that all you need is enough political power and the system can't touch you. But if the system works, If Letitia James is able to enforce this judgment, seize assets, and collect what the court says Trump owes, that sends a different message. It says that fraud has consequences, even if you're a former president. It says that judges and attorneys general can do their jobs without being intimidated by political backlash. It says that the rule of law isn't just a slogan, it's a reality. So here's what you need to keep an eye on. Watch whether Letitia James starts filing restraining notices on Trump's bank accounts. Watch whether liens start appearing on his properties. Watch whether Trump's legal team can find any appellate judge willing to hit the brakes. Because every one of those developments will tell us whether we live in a country where the system still functions or whether we've crossed into a world where power is the only law that matters. This isn't just a story about Donald Trump's legal troubles. This is a referendum on whether American justice is real or just theater. And trust me, the world is watching to see what happens next, so stay tuned. Because the next chapter of this catastrophe is about to be written, and it's going to define a lot more than one man's financial future. It's going to define whether we still believe in the system at all.